Hello student, welcome in 𝐼𝐸 Academy. Myself Tushar Shukla. In last session we have started fundamental rights and we have covered till the article 18. Today we will start from article 19. It is one of the most important fundamental right, and about this article you have often listened in news fundamental rights. So what the article says? Article talks about protection of certain fundamental rights. It contains 6 fundamental rights, which are as follows: freedom of speech and expression, to assemble peacefully without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of Indian territory. Last one but not least, to practice any profession or to carry any occupation, trade or business. These are 6 fundamental rights covered in part 19 of the Indian Constitution. Now we will cover one by one what is in this article subpart and what is in this subpart. Let's start with it. First article says or talks about freedom of speech and expression. Talks about freedom of speech and expression. You all guys will be aware about the speech and expression. What include? Freedom to express your thought. It can be done through both manners, through oral or audible, or second one is through written form, also in a print form. For example, myself, if I am not happy with the government of the present time or any other legislative or executive authority, I have a right to condemn them in a right manner. I have a right of speech and expression to present my views on the various policies of government, on the various issues which are prevailing in the society. It comes under freedom of speech and expression. No one can curtail your speech and expression, except there are certain conditions, especially during emergency. And in the part of 19(2), on the basis of certain condition, this right can be curtailed. Supreme Court, the apex court in Indian judiciary, has interpreted this article several times. For example, Supreme Court has said that right to press is also included under this article, which is 19(1) of the Constitution. What is that? Right of freedom of speech and expression. So what is also covers? Right to press. In the another judgment of Supreme Court has said that it also covered right to silence. For example, if any person, he doesn't want to express himself, he doesn't want to speak, then no one can force him to speak. This is also covered in this part of Article 19. What is covers? Freedom of speech and expression. which is a basis for basic fundamental right of an individual to express herself or himself. So we have covered the first part of this article. Now we'll talk about the second. Let's see what the second article is. Second is to assemble peacefully spelling in galat, and without arms. Now we'll look into deep. When a person has a right to express himself, okay, then they have also a right to assemble peaceful. Without arms. For example, you and your classmates or your friends are organizing a play or something in society. So what they have right to assemble peacefully. They can raise their voice in that manner. No one can stop until there is no illegal issue in that. So what we understand by this article? Every person has a right to assemble peacefully without any arms, and for this they have to take permission from police if there is any serious issue or any law and order issue is involved. So we have seen till now two articles. First is right to express speech and expression. Second is right to peacefully assemble and without arms. These are two articles. Now we will move toward third articles. Third article is right to form association or unions. Now the third part is right to form association and unions. It includes formation of clubs, formation of cooperative societies, unions. It has a very vast dimension. Associations. It could be any type of association until it is not involved in any type of illegal activities or it does not violate the parts 19 part 2 of this article. So we have seen that formation of association and union is a fundamental right of an individual. For example, if you are living in any society in Delhi, there are residential welfare association. They get power, or if they get fundamental right of forming their association from where? From this article, that is in Article 19 of the Indian Constitution, that they have a right to form association. Now we are moving toward the next part of this. Next is freely movement through the territory of India. To move freely throughout the territory of India. For instance, you want to go from Punjab to Haryana. If you want to go from Uttar Pradesh to Rajasthan, you go from MP to Maharashtra. There will be no barrier for you until there is some reasonable restriction over there. For example, if you have to go in a certain northeastern state, for example in Arunachal, then you have to take inner line permit. That is because to save their culture or their culture identity. So unless apart from that, there could be not any illegal or unreasonable restriction on your movement, because it is a part of fundamental right and that is important for you to utilize your potential and for your dignity. For example, if you want to do job in, suppose in Haryana, Maharashtra, in any southern Indian state, so there will be no blockage or no impediment in front of you. It comes under this part of Article 19. There are two more important things. This part of Article 19 covers movement within the country. While if you want to go to some other foreign country, then that will be covered under Article 21 of the Indian Constitution. That will be covered under Article 21 of the Constitution. Supreme Court has interpreted that a person has a right to move to other countries until there is any until there is any reasonable restriction imposed over it. So we have seen this part of Article 19, that a person has a right to move throughout a country without any issue until there is a reasonable restriction imposed over him or herself. Now we'll look into the next part of this article. The next part talks about to reside and settle in any part of territory of India. Now this part says that person has a right to settle or reside in any part of India, except when there will be some reasonable restriction will be there. For example, myself, I am from Uttar Pradesh, but currently I am residing in Delhi, and there is no one or no restriction over me to why you are staying here. You can't stay here for more than 1 year or 2 years. This power is, or this right is granted to me by this part of Article 19, which gives freedom to an individual to reside or settle in any part of India until there is any reasonable restriction even imposed on him. That is a part of this article. Now we'll see the next part. Next part talks about to practice any profession, to carry any occupation, trade or business. Which means, suppose as an individual, you want to start your any entrepreneurship industry, you want to start your any store, you want to take any agency of any company, you want to do farming. So no one can direct you except your parents will be there to do any profession. Whatever you want, you can do, or you can become a part of any profession, you can do trade in anything except the things which are illegal. For example, if you start dealing in drugs, narcotics, and when you are caught by police, then you will argue that I am doing my job and it is provided me under Article 19 of the Indian Constitution. Then at that time, policeman will slap you and say that you have a right to do trade or practice any occupation, but it does not include anything which is harmful for the society. That is not given, or that right is not provided to you. So I hope these 6 parts are clear to you. First one was freedom of speech and expression. Second was assembly peacefully and without arms. Third was to form association or unions. And fourth part was to move freely throughout the territory of India. Next was to reside and settle in any part of territory of India. Last one was to practice any profession, to carry or any occupation, trade or business of your choice. So it was all about these 3 articles. Sorry, about these 6 articles. Now multiple time in this section we have talked about reasonable restriction. What were the main reasonable restriction imposed on that 6 fundamental rights which are given under Article 19? So in this clause, there are certain reasonable restrictions which are enforced, such as in the interest of sovereignty of India, sovereignty and integrity of India, security of state, friendly relations with foreign state, public order, decency and morality, or in relation to contempt of court, defamation, or incitement of an offence. For example, if you walk naked on the road and you argue that it is my right to wear whatever I want or I do not want, but here you are just violating this principle. Which principle? Decency and morality in the society. So on that ground, police or authorities will not allow you to walk naked freely in the society. And second, you, in the context of speech and expression, if you start abusing your neighbors and or any other person, then that will be not covered under freedom of speech and expression, because you are now creating an offense. You are disturbing public order. For example, if you are inciting people to take arms against government, against your country, then also that voice will be curbed under the freedom of speech and expression. So you have to think about before speaking or before utilizing those fundamental rights about the reasonable restriction which are imposed on those rights. I am again revising this. For example, security of state. Your fundamental right or utilization should not lead to endangering of security of state. Friendly relation with the foreign state. For example, Bhutan is our friendly nation. So in that regard, in India, you cannot take out any march which is against the bilateral relation between or harming the bilateral relation between both the countries. You cannot abuse the ruler or the king of that country. These are imposed under the 19 subpart 2. Reasonable restrictions are imposed. In this session, two important things are, first of all, you have certain rights, that 6 rights we have seen. Along with them, there are certain restrictions if you are not utilizing your rights in the right order. So it was all about Article 19. Now we will talk about Article 20. It is also one of the difficult and important topic of this fundamental right. Article 20 talks about protection in respect of conviction for certain offence. It has 3 articles. We will look them one by one. First one is talks about ex posto law, which means that ex post facto law, sorry. It is included in the 20 part 1. So now what ex post facto law is that? You have to understand it. For example, you think that in present time in India, lesbian and gay marriages are not allowed. Okay? They are not allowed at present time. And many people are going for it. In recent we have seen in Goa or in Maharashtra, one marriage was held. And certainly there is no law in India whether such marriages are allowed or not allowed. For instance, in 2024, government make a retrospective act that in India, whoever has married gay or lesbian marriage, they will get a life sentence. They will get a life sentence. So as per this law, the person who has done marriage in 2021, they will be also booked. So this law, ex post facto law or 20 part 1, saves people from this one, ex post facto law. Such law cannot be applied in India. That protection is given under Article 21 of the Fundamental Rights. And one more thing, it is allowed in civil cases. For example, if the law is related with the taxation, then that can be allowed, but is not applicable in the criminal cases. So it was all about the 20 part first. We will read it once so that you can get more clarity. What the law says? No person shall be convicted of any offence except for the violation of law in force at the time of commission of that act. It says that when you are committing any act, you can be punished according to law that is implemented at that time, if it is in implementation. Neither you cannot be prosecuted for that law, not subjected to any penalty greater than which might have been inflicted under the law in the force at the time of commission of an offence. For example, for killing any person, currently there is a law that there will be 7-year punishment. I don't know exact what punishment is. For suppose 7-year punishment is that, and you have killed someone and you are punished for 7 years. For instance, in next 5 or 4 years, another law is passed that for killing anyone, there is a punishment of 30 years, suppose. So that law will apply to you who has committed a crime 3-4 years ago. No, this article protects that person, that this law will not apply to that person in a retrospective manner. So I hope this article is clear till now. Now we all talk about part 2 of this constitution. Part 2 of this constitution talks about double jeopardy. What do you mean by double jeopardy? It means that any person, especially in the criminal cases, cannot punish for a same crime twice. For example, you have beaten your friend and he has filed a complaint against you in a nearby police station, and the policeman has taken you to magistrate. Then now you are sentenced for 1 year. That for beating your friend. Again next year he files the same complaints that in the previous year he has beaten me. Then the court will say that that person cannot be punished twice for the same crime. You have to understand it in a simple word, that a person cannot be committed, that may be punished for a same crime twice. Now we will see it with an example. For example, there is a person A and person B. He is a thief. He went to his home, okay, for stealing, okay. During that night, what he did, he killed him and also stolen precious items. His family has filed a complaint against him. So for this crime, he has committed here two crimes. One is for killing and another is for stealing. So here he can be punished for two crimes, but he cannot be punished for killing him twice. This protection is given to a convict person who is accused or convicted under Article 20 Part 2. Now third article is also quite interesting. Third part says that no person accused of any offence shall be compelled to be witness against himself. For example, you have done any crime, then police cannot force you or magistrate cannot force you to become to accept your crime, and you become for self-incrimination that you have committed a crime and become a self-approval of against yourself. This is not allowed in a Indian criminal justice system. For example, what used to happen in earlier cases during British time or earlier? For instance, any person A has committed a crime. Police will take him to the police station and he will force him to become, by torturing him, to accept his crime, or whether he has done or not, that is not clear. In this case, what used to happen? Lot of innocent people were forced to to self-accept that they have done crime due to torture or by giving money or by torturing their families. This used to happen. So protect such people from the tyranny of justice. This article was inserted in the Indian Constitution. That is in the part 3rd of the Indian Constitution. It was all about the given article, that is part 3rd. Now we'll talk about the Article 21 of the Indian Constitution. It is a very important article of the Indian Constitution. It talks about protection of life and personal liberty. Protection of life and personal liberty. What the details? In detail we will see that no person shall be deprived of his or her life except according to the procedure established by law. We will also explain this term, what this term means. Procedure established by law. And here there will be no difficulty in understanding. Protection of life and liberty, personal liberty of a person. This article has a very broad dimensions. This article has a very broad dimensions. And in various cases, Supreme Court has interpreted it in a different manners. And we'll also cover what those interpretations were there. For example, in 𝐮𝐸𝐝 case, Supreme Court has done narrower interpretation of this article. What it did? Narrower interpretation of this constitution. At that time, it utilized the principle of procedure established by law. And it says that legislative laws can take the personal liberty and life of an individual. It was in the Gopalan case when Supreme Court interpreted this article in narrower sense. And after that, it was the Menka case in the year 1978. Menka case. In this case, Supreme Court has done the wider interpretation of this constitution. And in this interpretation, it utilized the due process of the law. What it utilized? Due process of the law. Right now we will see differences between due process of the law and that process established by law. So you have to remember these two cases, in Menka Gandhi case and in Gopalan case. In Gopalan case, narrower interpretation was done, and in this case, wider interpretation was done. And through the different interpretation, a lot of rights have been added under the Article 21 of Indian Constitution. For example, it has right to health, right to privacy. It was added in, I think, in 18. And this question was also came in UPSC examination, in which case right to privacy was interpreted under Article 21 by the Supreme Court of India. So you have to remember, and this case you have to give me an answer in comment section. Third is right to speedy trial. These all were interpreted under the Part 21 of the Indian Constitution. Under the Part 21 of the Indian Constitution, these all were interpreted. Now we will see the what do you mean by due process of the law and procedure established by the law. Established by law. So first question rises that from where we have taken this procedure established by law. From where we have taken procedure established by law. This was taken from the Constitution of Japan. Procedure established by law. In this, what happened? Supreme Court or any judiciary, we can, for sake we can say judiciary, look into the sanctity or constitutionality of any act on the basis of procedure established by law, which means any act Parliament has launched law that enacted, and if it takes the right of life and liberty of that person, then Supreme Court will have no problem. It will give a right that it will approve this act and take the right, that life and that liberty of person on the basis of act enacted by the Parliament. On the second hand, it is due process of the law. This is enshrined in the Constitution of USA. Enshrined in the Constitution of USA. Due process of the law. What is called due process of the law? What does it mean? It means that it has a wider connotation in comparison to the other concept. For example, in this case, if Supreme Court is giving any judgment or is checking the constitutionality of any act, then it will find that whether the act that has been enacted by the legislature, it is correct or not correct. Earlier, what was perceived? That the law which has been enacted by the legislature that would be correct. But in this, the law itself is questioned whether this law which is taking right to life and liberty of the person, it is correct or incorrect. So here we can see that a wide or clear difference is there, narrower description and a wider description. And in Indian judiciary is so much relevant in the present context in comparison to other constitutional courts in other countries. It utilizes both this concept on the basis of case to case, where which will be more suitable or favorable. So what Indian judiciary is now doing, it is utilizing those concepts under the part 21 of the Indian Constitution to protect the life and personal liberty of a person. One example I would like to give in the context of interpretation of Article 21. In Delhi, pollution was quite increasing a lot due to vehicular pollution and burning of stubble in neighboring state. So a petition was filed in Supreme Court that people or a children, it was filed on the behalf of a children, that she has a right of healthy environment. So that was also included or interpreted under a part 21 of the Indian Constitution, that a people have a right to healthy environment. So you can see that how the wider scope of Article 21 is. Now we are moving toward Article 22 of Indian Constitution. Sorry, we will first of all look into 21A, then we will talk about the 22 article. 21A, what it talks about? Right to education. Right to education. The state shall provide free and compulsory education to all children of the age 6 to 14 years in such manner as the state may by law determine. This article has the objective of providing right to education to the children up to the age of 14. Now there is a question for you. This article was later inserted in the Indian Constitution. So my question is, in which year this article was inserted in the Indian Constitution, and what was the name of that amendment through which it was inserted in the Indian Constitution? On the basis of deriving the power from this act, Parliament has enacted Right to Education Act, that is RTE Act, I think in the year 2009, that provide for 20% reservation, 20% reservation in the private school for the weaker section of the society. This has been done on the basis of Article 21 of the Indian Constitution. Under which article? Article 21 of the Indian Constitution. There is not much to explain in this. Now we are moving toward next article, that is 22. Now what Article 22 talks about? Article 22. It gives protection against arrest and detention. It gives protection against arrest and detention. In India, in Indian criminal justice system, there are mainly two types of arrest or detention, we can call them. We'll first of all look them, then it will be easy for you to understand the whole concept. So what is there? Detention. It is of two types, punitive and preventive. Now we will look into the difference between punitive detention and preventive detention. For example, earlier example I have given you that you have beaten your friend and he filed a complaint against you, and police came and that put you behind the bars. That is which type of detention? That is punitive detention. Means crime has been committed and the accused person has been put behind the bars. That is punitive detention. Now what is preventive detention? In preventive detention, what happened? Person is put behind the bars or detained by the police before committing a crime. For example, if someone tells you this Mr. 𝐻𝐸𝐽 is coming to kill you because he is angry with you, then what you will do? You will inform police that he is coming to kill me. Then what will police do? Police will detain him before committing the crime. What will be that? That will be a preventive detention, in which person is put behind the bars or detained before committing any crime. Now I think difference between preventive and punitive crime is clear. Now we have seen that in punitive crime, person has a certain rights are given to him. For example, we will look into no person who is arrested shall be detained without being informed. A person has to be informed why police is detaining him, on which ground he is being detained by the police. And also that person should be right to consult, to be defended by a legal practitioner. If you are put behind the bars in the case of punitive detention that we have seen earlier, in that case you have several rights which are granted by this article of the Constitution, that you should need to be informed about on what basis you are detained or arrested. Second is, they will provide you facility so that your legal practitioner, who is your lawyer, can defend you, and they have to take you to the magistrate office in 24 hours. If they are not able to do that, then they have to release you on that ground. So what this article provides? This article provides certain protection to the people over their arrest and detention. Now in second part, same thing is talked about. A person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest. So there cannot be any arbitrary arrest or detention of any person. It has to be presented in front of the magistrate. Then what decision magistrate will take on the basis of case which will be put in front of them, that will be final. Next is, any person who is for time being these things are not available to the person who is an alien to the country. Means he may be from other country. To the person who is arrested or detained under any law providing for preventive detention. For example, UPSC Act, which was enacted in the 1967. Under that act, if that person is arrested under that act, then this act, which provision we have talked earlier, will be not applied to person who belong to these two categories. First of all, he should be an alien citizen or enemy citizen. Second, if they are detained under any specific law, then the upper provisions will be not implemented on them. Now we talk about preventive detentions. No law providing for preventive detention shall be authorized by determination of person for longer period of 3 months. Means if any person is detained under preventive detention, so their detention period will be not more than 3 years. Their detention period will be not more than 3 years. It is given under part 4 of this article. Next we are going to see advisory board should be consisting of person who have been qualified to be appointed as the judges of High Court, has report before the expiration of said period of 3 months that there is opinion sufficient cause for such detention. If it has to for 3 months, or it has to be improved further, it has to, and that period has to be increased, then a such advisory committee, its recommendation is mandatory in this regard in the case of preventive detention. Now there is more stuff in this article, that Parliament, which can make laws on the preventive detention, by law prescribe that the circumstances under which the class or classes of cases person may be detained for a period longer than the 3 period, means in which cases he may be detained for more than 3 months, that will be decided by or prescribed by the Parliament of the country. It is a sole prerogative of Parliament. And for this, if Parliament has prescribed, then there will be no recommendation of advisory board will be there. So we have seen that punitive detention, what right person has, and what are different facets of preventive detention. Now we are moving toward Article 23 of Indian Constitution. We are moving toward Article 23 of Indian Constitution. Now what this article talks about? This article comes under freedom against exploitation. So first part of this constitution, or first of all we'll see the heading of this. Prohibition of traffic in human being and forced labor. Means Article 23 says there will be prohibition or abolishment of traffic of human beings and forced labor. What the traffic of human beings means, the trafficking of human beings means they are sold from one place to other place as an object. For example, in the case of prostitution, in the case of their different body parts are sold, this comes under the trafficking of human being. And what the forced labor means? Again, forced labor means during that earlier time, what the Jamindar used to do, they used to capture people. The forced labor can be also in terms of slavery. They are forced and they are not given adequate salary or wages, or living condition is not provided by them, and forcefully lot of work pressure is imposed on them. So it constitutes a forced labor. Even in present time, there are a lot of cases of forced labor is there, which we called as a modern slavery in the present time. It also includes the earlier system of Devdasis, which were used in the temples, where the certain girls of certain age groups were being employed as the Devdasis to perform dances, and in that duration or in the meanwhile they are sexually abused by the people or owner, that people who were the head or leading that institution. So it prohibits the ancient tradition of Devdasi system, slavery system, forced labor, trafficking of human being. Let's see what the article first, that part first talks about. Traffic in human being. Beggar, you can't force anyone to go in a business of begging, because there are big cartels where in the big cities like Delhi, Mumbai, Chennai, they are running cartels where they used to bring children and force them to beggar at at where the traffic lights are there, and other similar forms of forced labor prohibited. Any contravention of this person shall be an offence punishable according to the law. If you are found to doing this practice, trafficking of human being or making any people to do forced labor, then that will be considered as a crime, and different acts have been enacted by the parliament, and under those acts the person who is committing this crime will be punished very harshly. The next which it talks about, nothing in this prevent the state from imposing compulsory service. For example, there are certain countries where military participation or military service is compulsory, so that will be not included under the forced labor. For example, that COVID was there or any other disaster come in country, then government of India can make a provision that the person of certain age group, person of certain gender have to perform certain duties. So in that case, it will be not considered as a forced labor, because at that time people are doing service to their nations. It can be made by the Article 23 of the Indian Constitution, and that will be not considered under forced labor. Now we will move toward Article 24 of the Indian Constitution. What the Article 24 says: prohibition of employment of children. It prohibits the employment for children. Let's move further. No child below the age of 14 years. No child below the age of 14 years shall be employed to work in any factory or mine or engage in any other hazardous employment. The Article 24 talks about the welfare of children, that up to a certain age limit, they cannot be employed in any hazardous industry such as mining or factory, which is hazardous for their growth, for their health. In many parts of the country, people are preferred over the adult population as a labor because they are cheaply available, and many times they are abducted from their homes, their cities, and they are taken to the other places, and they are kept as a forced labor to use to work in a different industries. So in that case also, this article says they cannot be employed in a hazardous employment which is dangerous for their health. If anyone found doing contravention of this article, they will be punished according to the different laws that has been enacted by the Indian Constitution. This was all about the today's session. Today we have covered from Article 19 to Article 24. In the next session, we will cover from Article 25 and will try to finish up to Article 35, because mainly that right to freedom will be left, and after that different few minor portion will be left. So thank you guys for watching this session. We will meet tomorrow in the next session, and have a nice day.